Welcome to the Law Shit You Should Know podcast. We're here to talk a little bit about the law
and a whole lot about nothing. Every week, we have a new guest to discuss current events, legal drama, and dive even deeper into
the Law Shit You Should Know. Hi everyone, and welcome to Law Shit You Should Know with ElIna Santana
and Leslie Marenko.
And today we have the amazing Dylan Gonzalez.
Our illustrious guest.
Illustrious guest, yes.
How you guys? I'm doing great. How you guys doing?
We're good. So tell our viewing and listening audience what you do, who you are.
So my name is Dylan Gonzalez. I'm a personal injury attorney down here in South Florida. Our office is here in Coral Gables. We operate throughout the state of Florida, and we specialize in trying cases. We have a good combination of cases that we either will take from other attorneys that work in the personal injury space that don't want to try cases, that don't really want to heavily litigate. We found that obviously you maximize your recovery and your settlement when you go to trial, when you litigate, and you put that type of pressure on the insurance companies. And then, the other half of our practice is just organic stuff that kind of comes in, just normal walk-ins. Friends, family, people find you on the internet and things of that nature when, they get hurt. And that's primarily what we do. I've been a personal injury attorney out of practice now that we started about 6.5 years ago. It's me. I have 3 other law partners, and we've grown to about a staff of 20, 22 now. We just got done hiring a couple other attorneys recently, and it's been a long journey. It's been a long journey.
And is that all you do in your office, personal injury? So
I do 95% of personal injury. I was a baseball player back in the day. I grew up, born and raised here in South Florida, and so then I have a sports representation side of my practice too. Just that I dabble in. It's really nice to kind of give back and just kind of.
Wait. So what does that actually mean? Because we might have many other personal injury attorneys on this podcast, but I don't think we've ever heard anything about sports agent.
So basically, I played ball. I was born and raised here in Miami. I played baseball ever since I was like 4. And I was fortunate enough to be, decent enough to play in college. I played professionally for a little bit. And I went to college out in California. I always wanted to kind of get away. And so I had opportunities to play here at Miami. I signed my letter of intent actually at University of Florida back in 2003. And when the opportunity presented itself for me to kind of get away, which is something I was really eager to do, just growing up down here, I did. And I went to California, got drafted out of high school by the Giants, got drafted out of college by the St. Louis Cardinals, and then I went to go play for a few years. And at that point, once my career kind of came to an end, it was right around the time I went to law school. I was ready to be done with baseball. I had opportunities to go work in the front office and do not necessarily like coaching stuff, although I could have. It was really more of, save the track to become a general manager. But for me, to be honest, when baseball or hockey or basketball, whatever it is that you're pursuing is like such a big part of your life, I was ready for a change, and I wanted to do something that mattered, do something that was, more impactful for me, for my why, my purpose for existing, and I became an attorney. And so when that...
So are you one of those happy attorneys, though?
Yeah, I mean...
No, I'm still trying to get to how do you represent
so which is
happy
where...
attorney.
Which is where I'm getting to. So then, once I had gotten enough space in between me and, say, baseball, it was nice. So
this was purposeful. Like, the way you're describing it is
very happy. It was a plan.
Okay, cute.
Okay.
Exactly.
Just fall into it.
Okay.
And so...
but you needed space between you and baseball to even, start...
Yeah, thinking about it again, and for, people...
It sounds like there's, pain or something back here. Not other podcast guys.
To be honest with you, I think that if you speak to a lot of guys that play baseball... really a lot of sports, and they play it seriously from a very young age. But I find it, for some reason, I don't know why, but with baseball more than any other sports, you'll see golfers, they kind of go and play golf after they get done playing, You'll see tennis players that'll go and still hit. You'll see hockey players that might even kind of go play, afterwards. You don't really find a lot of baseball players that play, let's say, at the higher levels in college or professionally that will then go play in an adult league like the Nika League in Tamiami. And it happens from time to time, and everybody's different. But I know that a lot of my friends and a lot of people that I played with, when we were in the locker room, we're like, listen, when we're done, we're fucking done. And that's kind of how it was. And for me, I could never quit. I was really looking more for permission to move on from the game. And so when I got released from the Cardinals organization, although I had an opportunity to go play with some other teams, and I could go and play like in Colombia or in the Dominican or Mexico, whatever, it was permission for me to kind of let go and then start focusing on something else, and for me that was the most important thing. Now, to answer your question, how I got into it is that once that space kind of went by, I had a good foundation with our personal injury practice. Being a sports agent is a very cutthroat and kind of miserable early years of existence, because you have people that are flip-flopping from one agent to the next in the locker room just based on, who's got the nicest glove or nice shoes and things like that.
Fulanito got a better deal.
Yeah, correct. Exactly. And what a lot of players don't really understand and realize is that a lot of the guys in minor league ball, unless you were a top draft pick or a really big time sign, you don't have that pedigree to go and demand, say, a deal from Nike or a deal from Rawlings. And so what's happening? You as the sports agent are actually fronting or investing in your player and actually paying for a discount because, you have a relationship with Rawlings or Wilson or Louisville Slugger, whoever it is, but this is an investment, and so before you get into that space, it could be definitely not just a time suck, but a big money drain if you are choosing the wrong players, and then you have players that are literally just kind of leaving to the next, flashy object in the room, So for me, it's more of a passion thing that I enjoy doing, but it's not like a necessity, We pay our bills with our personal injury practice, and we've been fortunate enough to be really successful with it. And so, I had a very good relationship with like a lot of the Latinos, when I used to play. And I think that stemmed from my desire and my passion just for like geopolitics, international relations, and other stuff like that. So I was like searching for something different. And so when I was playing ball, I kind of, nestled in with like the international crew. And so like, my Spanish
I
is
thought
like
they were like all international crew. Are
no. Like there's
any Americans playing baseball anymore?
In the locker rooms, you'd have like a
What's
good
an
blend.
American?
You'd have a good blend between, I'd say it was like 60 to 70% of the dudes like be here from the States, and then you'd have like a good 30-40%, be from the DR, Venezuela, Cuba, wherever, Mexico from time to time. It also depends on the organizations, because each organization might have like a different focus. Like some, like the Houston Astros, my dad actually happens to work with the organization, and he's had a really great career. Couldn't be prouder of him. And he's actually known for actually signing a lot of Cuban players, and Houston Astros has a very large Cuban population in their farm system. Other teams, might have more of a focus in the DR, others might have a focus with Venezuelans. Things these days are a little bit more difficult on the Venezuelan side, obviously, just because of the condition and the state of the country, but, it's all different. So that's kind of how I ended up getting back to it. I had been presented opportunities in the early days of our practice from guys that are actually in the big leagues, and my dad would be looking at me, he's like, see? He's like, that guy just signed a fucking monster deal. He's like, you could have had him. And it was like, and
thanks, Dad.
I was like, thanks.
It in.
Yeah, for sure. I mean, that gave you an idea of like what it would be like growing up with a father after a baseball game, which everybody knows that's like. It's like, oh, you should have fucking swung at that, or you should have been more aggressive here. But it doesn't stop when you become a grown ass adult. I'm turning 39 next year, and I might as well be 9. So.
So when you say you represent them, are you representing them on the agent side or more legal side? Because you said it was part of your practice.
So, I mean, it's a part of my practice, a very small fraction of it. I mean, I only have a couple ball players right now, and they're in the minor league system. And they, it's really more of kind of like you do it all a little bit for them, because as a sports agent, you're not really just managing their contracts. But you're also,
their lives.
Yeah, you really are. Whether it's like, hey, a player might have a run-in with the law. What do they do?
I was just going to say, this is like, you better not be doing hookers and coke right now. We have a game tomorrow. Yeah. Whatever it is.
Yes.
I feel like there might be a huge financial planning aspect to this, right? I always hear stories about how players get in trouble with these big contracts, and they blow all the money, and they have no concept of like, you're going to do this forever,
Yeah, for sure. I mean, I had a player, he had a couple different cars within the first year. I was like, dude, that's not the best, way to spend your money, especially if you're going to be away playing ball for like 9 months and you're only going to see your car for like 2 months, Other clients, might have an issue with, because again, they might not know the laws in the state of Florida. So do they have to have PIP? Do they not have PIP? Did their insurance agent put them in the right policy? Are they going to get their license suspended because they don't have PIP? It's good because I actually happen to have experience on that end because I'm a personal injury attorney as well. So that's helpful. But, you're doing all sorts of stuff. And then also, and I find this in my personal injury practice too, because when you are fortunate enough to be able to help people with their problems, they will then think of you for all of their problems. So I'm a personal injury attorney. And, we go out of our way to make sure that we provide proper customer service and good representation. But then, you are able to kind of gain that trust. And then next thing I know, I had a client who was catastrophically injured, multi-million-dollar settlement. And he calls me for a promissory note because he wanted to, engage in some type of, business lending scheme with somebody else, and things like that, So yeah, you just kind of have to know a little bit of everything.
No, or
at least on the baseball side. Yeah, exactly.
Calls,
correct,
right?
exactly.
I like that.
Yeah, because I'm assuming you guys on the weekend aren't drafting promissory notes for.
This is correct. That would be a very, very bad use of our time.
Yes, it would.
Yeah.
So you are primarily a personal injury attorney. So let's talk a little bit more about that, if you don't mind.
Yeah.
I feel like this is a super hot topic in law right now, is personal injury. Everybody's talking about all the changes that are going on.
At least you're in Florida.
Well, I was about to say not really, right? Yes, huge topic in Florida. A couple of our guests have mentioned it. I think it's been all over the news. Most people, I think, know there's something going on, even if they have no concept of what it really is. And I think most of our listeners and watchers know we're based in Florida at this point, just because of our guests. But there are...
If it wasn't obvious.
But it's not just Florida, right?
Yeah.
So in prepping for the podcast, you sent me some stuff that had been going on in Iowa. So tell us about that.
Yeah, so I think the way I'd probably want to frame that is that with respect to the lawsuit that happened in Iowa, it was really more of just to kind of provide people an insight of the lengths that insurance companies
So wait, I don't know anything about anything in Iowa.
Yeah. You gotta start from the beginning. So tell us what happened.
So basically,
who said who, why?
So there's a famous trial attorney. He's out of California, I believe. His name is Nick Raleigh. And he is, one of the juggernauts in this space, an incredible trial attorney, has had incredible results. And frankly is somebody that, I look forward to kind of just reading up on and reading a lot of the materials and stuff he puts out because he's a really a great trial attorney. And I think a great example of what trial attorneys should be aspiring to be like and what they should be doing. But basically he had a medical malpractice lawsuit that led to some brain defects for a young child that was born. The family ended up bringing a lawsuit against the small practice there in Iowa.
They female-owned OBGYN.
Correct.
Practice.
Correct.
Three women doctors.
Exactly. And
against what, their insurance carrier and everyone else?
Well, it was a third-party situation, so the lawsuit from the family would be suing the practice itself. Obviously, they would have their own liability carrier, at which point if they get a demand letter, they get some type of notice that they're going to be sued, they would notify their insurance carrier so they can do their due diligence and investigate whether or not they need to provide coverage and protect the OBGYN practice. Now, based on, I don't know all the facts on the case, but these are just the general points, is that they were in communication and negotiation talks with the OBGYN practice. And it appeared that both sides were interested in potentially resolving. Now, obviously, the OBGYN practice might be interested in resolving, but they then have to go up to the higher-ups at the insurance carrier to be like, hey, listen, we have this, and that. This might be favorable to us or might not be. These are our concerns. Should we settle? Should we not settle? Are you going to settle? Whatever the situation is.
Yeah, it seems like all the parties were ready to settle.
Correct.
Basically.
Right. And that appears to be what was going on. However, the insurance company did not settle. And so the question then becomes, why did they not settle? And
so they said, no, take that shit to trial.
Well, their actions seem to kind of put them in that direction, So it appeared, at least based on the information that I've read, that's out in just, the internet and news articles and things of that nature. They were interested in settling within the policy limits that the OBGYN practice had. So could be $10 million, could be 50, could be $1. We don't know, but we know that
it is they were covered for.
Correct. We know that the plaintiff, the moving party, Nick Raleigh, and his clients were interested in settling within the policy limits, and the insurance company did not tender the policy limits and actually forced this matter to go to trial. Right.
Okay.
Now, what ends up happening in that situation is that you can go to trial and you ask the jury for an amount, right? You're not telling them that, hey, the policy limits were $1 million or $10 million. You ask them for what you believe the claim to be worth.
Right.
And the jury will then end up providing what the claim is worth, what they believe the claim is worth. Now, in some instances, that verdict can be well in excess of the insurance policy, or it can be well below. There might be laws at play that cause or create an offset that then maybe bring it down within the policy limits. Mm-hmm. What we do know is that his verdict was somewhere over $90 million. It might have been 97.
Oh, shit. Yeah. $97 million.
It was $97 million for the brain damage that was caused to the child. Mm-hmm. Obviously, it goes without saying, the business probably would not be able to survive that type of verdict, right? Because
they bankrupted the OBGYN's office.
Well, they filed bankruptcy, and they're not doing things to try to insulate their need to end up paying. Now, the thing that's interesting here, and this is the part that I don't think a lot of lay people know, and frankly a lot of other lawyers know, are the lengths that insurance companies are willing to go to change the law. Because maybe they pay a $100 million verdict here, right? But they might save tens of billions of dollars over the course of, the next 10 years based on the laws that they were able to change by using this one example. And the reason I say that is that it's actually a little bit of personal experience from other things that we've done when we first started our practice, which we can get into. But a perfect example would be to think about the McDonald's case, and you think about like just different talking points that people will have, out in the public, because it's very easy to incense lay people that are struggling with their daily lives, that are just trying to find, happiness in what they're doing. I deal with it. I'm sure you guys deal with it. Everybody is trying to find their purpose and what they're happy with. And when you hear a story about like, oh, somebody just got, $5 million, for spilling coffee on their lap, what you don't think of is 180-degree, liquid being spilt on your lap from a 70-year-old woman that then all of a sudden had, third-degree burns and needed skin grafts, because they don't leave that in the article or the commercial, or they don't show you the photographs of the skin like melting off of her body,
the McDonald's case was publicized as one of the most frivolous lawsuits ever, in personal injury.
Correct.
It was a long time. It was in the 90s.
Yeah, for sure. Yeah, for sure. And so then,
I actually remember this. I was a kid, and I remember this lawsuit.
Well, I don't even remember that until I actually got to law school, and that was something, because I went to law school in 2010, and that's the first time I heard of it. You know what I mean? But it stood the test of time for people to still be talking about it.
Yeah.
And so the reason I bring that up though is because obviously the insurance company, the argument would be, if this is in fact true, but it would not surprise me just given the things that we've experienced and the things that we've seen, is that they have a small, female practice, private practice, OBGYN practice in the state of Iowa. And now these poor doctors are going to have to now go out of business, because of this crazy big lawsuit, and it's only because these greedy personal injury attorneys are out there, making these things happen. We need to change the laws and protect these people, from these, incredibly greedy trial lawyers.
So what has happened in Iowa is that the insurance lobby is using this case as a way to try to change the law.
So the counterpoint is now that the insurance lobby is saying, look what y'all did, all these personal injury attorneys suing everybody, and now, these 3 female OBGYN small practice, we've destroyed their business.
Right.
They've had to file for bankruptcy, they're leaving the state of Iowa, thus we need reform.
Right. And the thing that people would not necessarily know, right? All the lay people that are going to then go vote on these potential tort, reforms in the state of Iowa, what they're not told is, hey, there's something called bad faith. There's something called, where the insurance company has to look out for the interest of their insured, which was the OBGYN practice.
Right.
And at the time in which they knew what the facts were of this case, and they knew what the exposure of their insured would be, right? Because you have the insurance and all this money here to protect whatever judgments or whatever claims might exist. And so when they see that there's a child that will have this brain defect and might, need, $15 million for the rest of their life, and they only had a $20 million policy, the insurance company is supposed to put the interests of you or their insured above their own and not think about the money that they would save. And they should be chasing down that person to basically hand them a check for $15 million if it's going to end up settling for something around that money, right? And if they don't, And you then, as the injured party, have to go hire an attorney who then needs to take a fee, right? Because obviously the insurance company was not going to do the right thing until you got involved. Well, then now that person that is you're the injured party, right? Say the family there, is then going to be without funds because they have to hire an attorney, and that attorney is not free. He's going to have to take a percentage of that. And so that money that otherwise could have been dedicated towards, life care planning and everything else is now going to have to be shared with the attorney so they can go and teach a lesson to the insurance company and get you a recovery. But then the law provides something, under the bad faith laws, which basically says if the insurance company appears to be putting their interests ahead of their insured, that there is no limit in essence to what that policy said. So like you might have had only $1 million policy.
Oh, interesting.
But if the insurance company put you in a position to where you might be liable for $20 million, because that's what the jury said the verdict was worth, well then that insurance company, would potentially be on the hook for that.
Because they are the ones that refuse to settle.
Correct. And the insured was perhaps interested and willing to do so. Because if there was no bad faith, right, what would actually happen in a lot of those situations, let's talk about here in the state of Florida, because I'm not an attorney in any other state, and I want to make sure that I'm not getting in any trouble.
No, yeah.
But here in the state of Florida, for example, you have and this is a case actually I just dealt with, somewhat recent, and I have to keep it, pretty ambiguous because it was a confidential settlement, but
sure.
It was a young kid in his early 20s, had a terrible slip and fall accident that resulted in a fractured spine. He's going to be in a wheelchair for the rest of his life. Beautiful, beautiful family, beautiful kid. I couldn't have been, more privileged to have, him come to us to represent him and just kind of guide him throughout that process. And that was, by the way, the reason why I stopped playing ball. It was like for moments like that, where you can actually really impact real change. And anyways, in his situation, the insurance company did not tender the policy, which happened to only be $1 million, right? And so you have a young kid in his 20s that is now a quadriplegic, which by everybody's, I'd say experience, even as a non-lawyer, it's a $50 million case or more. You know what I mean? Like your life has been changed forever.
Yeah, it's tragic.
Yeah. You can't. I mean, just where do you start in terms of how it is that your life has been impacted, right? And so
they didn't tender.
They did not tender the $1 million policy, correct?
$1 million.
$1 million, correct. And so in that situation, they even had, and this was the analysis at least at the time. They had been provided a release that allowed the insurance company to get medical records. They had been provided the opportunity to investigate the claim and see what was going on, even though information had been provided to them, and they still did not do anything. We were approached about 2.5, 3 months after the actual incident to then say, hey, Dylan, what's going on? What can we do? Is there anything that I might have? I have hundreds of thousands of dollars in medical bills. My life has obviously been changed. We don't know what's going to happen next. And at that point, I put together a demand letter, with all the necessary photographs, depicting what it is that actually occurred, advising the insurance company what happened, telling them where it happened, and all the other circumstances that were involved, attaching medical records that showed the condition. And again, it said he was a kid in his early 20s, was a quadriplegic, which you would think is all you need to know. And at that point, they asked for more information, which was a blessing and a curse at the same time. It's sad, right, that the insurance company is still trying to withhold these funds from somebody that would obviously need them. But because, thankfully, of the laws that we have here in the state of Florida, we were able to make sure that we quadrupled, or roughly quadrupled that policy amount, so that he could actually have more funds to kind of take care of himself in his future, Now,
I was about to say, so that's still true under all the...
So is it the injured party that says this is bad faith, or the insured that says, fuck you, insurance, I've been paying you all this time, and now you don't even want to tender a fucking measly $1 million keeping me in this goddamn lawsuit?
Exactly, and that's actually the point of the story, is to kind of talk about, so in this situation, if there was no bad faith, right, and you end up suing the business that was responsible for his injuries, and let's say there was only $1 million in coverage, and you go to trial, and you end up getting a $30 million verdict, okay? The insurance company, if they tried to tender, and then you say you did have a greedy personal injury attorney and said, hey, I wanted to go and just get a really big verdict and see if I can hit the insurance company for bad faith. Well, it's not guaranteed that just because you get a $30 million verdict, that you're going to have that coverage from the insurance company to cover it. And frankly, most businesses would not have those types of funds unless you're suing like a Johnson & Johnson or a FedEx or something like that. And so what would end up happening is you would then, after you get the $1 million from the insurance company, after you got, say, a $30 million verdict, and then you would have to turn your attention to the business owner and say, okay, let's, pay up. You got to pay my client, right? For the terrible damages that you caused my client, right? Now, in that situation, the guy is either going to go, or the woman is going to go bankrupt, right? Or they're going to pay up, or they're going to ask for a payment plan, or maybe they would try to settle with something else. Maybe you don't get a $30 million verdict. Maybe you can only get, $800,000 more, or whatever the situation is, because you just know that you can't get blood from a stone,
Yeah.
Now, that's in a situation where there's no bad faith, right? Because the insurance company did what they needed to do. They wanted to pay the $1 million, but the attorney and the injured party did not take it. They went to trial, and now they have to look for their recovery, not from the insurance company, because they were only insured to provide up to $1 million, and then they have to look to the business that caused the harm for the rest.
Mm-hmm.
But in a situation where you have a bad faith context where the insurance company had an opportunity to settle for their insured to protect the business so they did not go out of business, because they knew that the reason that they had this insurance is because they were trying to prevent
they don't have to go bankrupt.
Correct, go bankrupt or use their personal funds from their bank account or whatever the situation is. And so the insurance company has a duty to put the interests of their insured above their own and do what a reasonable insurance company would do, given what the facts and the circumstances are at the time. And so in this situation, like I said, the good and the bad of it was that the bad is that the insurance company is doing what insurance companies do a lot of the times. They put their interests over their own. They're a publicly traded company. They care about investors. They care about money. It's a whole, different conversation. So they just held on to it and continued to make the personal injury attorney work and withhold those funds. The good thing is that every reasonable, objective adjuster would know, if you had a young man in his early 20s that just was paralyzed as a result of your insured.
Yeah, it's not a $1 million
case. It's a $50 million case or more. Now, the thing that was crazier about it, and this is the sad truth, is that in the state of Florida, there's something called comparative negligence, which did just kind of get modified and changed a little bit in March of 2023. But in this situation, the reason why it was even more obvious that it was a bad faith situation is that, our client was engaging, he wasn't necessarily completely, not blameless, but I would just say there was a certain portion of the behavior that was being engaged in that may have been avoidable, right? And so in the state of Florida, under the old negligence theory, which was pure comparative negligence, basically said that the jury can apportion the amount of fault to the tortfeasor, the person that causes the harm, and then obviously, apportion the rest to the plaintiff, the moving party, if they believe that he was partially responsible for his own injuries. So you can think about a rear end accident would be a good situation where, generally speaking, the person directly behind you is going to be 100% at fault. That's the reason why the presumption exists, because you're seeing what's happening in front of you. You should have slowed down, been traveling with enough distance in between the two vehicles. But if, say, you go between a car intersection, and let's say it was a yellow light or it was a red light, or you had the green light, and you're going through a green light.
And you slammed on the brakes.
Well, not even that you slam on the brakes, but you're going through a green light, and you see another vehicle coming from, let's say, 500 yards away, and it's speeding. And the facts come out at trial that you could have taken evasive action to avoid it. Slow down. Yeah, you had the green light, but what are you going to do? You're going to barrel down the intersection even though you have the green light and then T-bone the other car?
Hit me, fucker.
Right.
Only in Miami.
Only in Miami.
What, I mean,
I'm not going to lie. I've had moments in traffic where I'm like, come at me, bro.
Well, and not only that, I mean, obviously that's the different conversation is that, maybe there are people, sadly, that do need to be regulated because maybe there are staged accidents from time to time,
That's a whole different conversation. The accidents that happen with your 15 cousins of Hialeah all in the car.
I am a lawyer after all.
I represent a lot of people who've gotten themselves in some fraudulent accidents and got themselves in immigration trouble.
Allegedly fraudulent accidents.
Not even alleged, because I have to admit it to even start with the immigration process.
So, as it relates to, the car accidents and say a T-bone intersection, or a T-bone accident in an intersection, you're going through and say you see somebody, even though you have the green light coming and you could have avoided the accident, and let's say the jury ends up putting 85%, or 90% on the party that ran the red light.
Mostly their fault, but a little bit your
fault.
But
they put 10% on you because, hey, you could have done something, you should have been paying attention. Maybe you were on the phone too, and so even though you had the green light, if you were on the phone, you weren't talking, you weren't distracted, so you're going to get some, So in our situation, though, as it related to the slip and fall, where my client was, paralyzed, I told the insurance company, and this was something that was made very clear in the demand letter, it's like, guys, listen, even if you want to take the position that our client had a certain percentage of blame in this particular incident, you're talking about a $50 million, injury. You're talking about tens of millions of dollars. We know one thing, it's definitely in excess of $1 million policy. And so even if it's in excess of the $1 million policy, and let's say you just put 90% of the fault on my client, right, and 10% on your insured, that still leaves you.
You still gotta pay.
Yeah, correct.
Yeah.
And you have to pay not just like a little bit, but you have to pay over your policy of $1 million because, 10% fault of a $45 million verdict is a $4.5 million, verdict, right? And that's what I explained to them. And we mock tried it. We did focus groups. We did this right. We filed the lawsuit because they did not respond. They never even sent us the letter saying what the insurance policy was. So throughout this entire process, I still as the lawyer did not even know if there was coverage in this particular case.
Yeah.
What pajarito insurance company was this?
Yeah,
I mean, is this like a Doro?
Can't tell you.
Is this State Farm? Like Estrella Insurance? Is this a legit insurance company?
Listen,
can you at least say? I mean, is this like?
So
Jose Pablito Insurance.
It was definitely a confidential settlement, so I couldn't say. But what I could say is that it actually was a very reputable and very legit insurance company, and something that you would not have expected, from someone of that.
It's the gecko. I know it. It's the gecko. No, I'm kidding.
Which then again, goes again just to kind of magnify and show you that these insurance companies, a lot of the time, what they do is a little more calculated and nefarious than I think people kind of lead on. Because in the situation in Iowa, what's happening is they see this. And you ask yourself, okay, well, why are they not going to then just protect this OBGYN all-female practice and empower this practice to continue to thrive and succeed? Well, because maybe as they are doing some type of side deal and telling the OBGYN practice, and this is all theoretical because I have no idea and don't know anything about the facts of the case, but let's say, assume for a second, hey, guys, we got you, we'll protect you, we'll make sure that you guys are set up, we'll pay for all this other type of stuff, we'll assist you in maybe some type of other side deal and make sure that you guys don't die and continue practice, medicine or whatever. But let this case ride, we're going to use the results to kind of help change tort reform because, at the end of the day, it's just ridiculous that someone would have to pay $97 million for this type of situation, right?
You say that, and I know you say you don't know the facts and blah blah blah. I can tell you, I went down the Google black hole with this case, and I was reading, and yes, of course I did. This is what I do, and I'm not nearly as afraid. He works in this industry, I don't. So
she's nearly as afraid to talk shit right now about what's going to happen.
Yeah. I read that there were text messages showing what they wanted. There were emails. There's actual documentation that this
of
collusion.
Some type of
that they were essentially, this is the case, the test case, and we're going to convince all these legislators to pass some sort of reform.
Well, I was going to say, in the OBGYN,
poor doctors who you've bankrupted.
If I'm the OBGYN and this shit goes south, you motherfuckers are the free spirit. I'm going to sue, right? Yeah. My own insurance.
Well, and that's where the bad faith kind of component comes into it, right? Because you generally, as you're going through this process, it's a long process. It might take a couple years to kind of get to trial. Throughout that time, and as an OBGYN, business owner, you're going to see your house burning around you, and you might be telling your insurance company, "Hey guys, settle the case. What's happening? Whatever." Yeah. And if they don't do that, you also know, and you're likely going to get counsel from your either personal counsel or from the attorney representing you on the case. And be like, these are the other things that you have available to you, because if your insurance company is not taking care of you, you may have bad faith, and bad faith action against your carrier. Now, what ends up happening is technically the OBGYN practice would have the bad faith case against the insurance company.
Their own carrier.
But what they would do is they would assign the rights, and again, I have no idea how things work in Iowa, but this is generally how things would be. they would assign the rights to the party that just obtained the $97 million judgment so that they can then sue the insurance company.
Oh, Jesus.
And then, Nick Raleigh can go have some fun and basically, make an example of what's going on. Because if you in the article, they asked him, it's like, are you concerned? He's like, it's going to be a difficult case to prove. He's like, yeah, not really. He's like, it's not.
There are text messages.
He's like,
there's written evidence.
Right. He's like, no. He's like, I'm not too concerned. He's like, because we're going to get everything. We're going to get the emails. We're going to get the text messages.
Yeah.
We're going to get all of these things. And you know what? Good for him, and I hope he does. Because the other side of this is that insurance companies are emboldened a lot of the time because not all attorneys will go the extra distance. In fact, a lot of them will not. A lot of them won't try cases. A lot of them won't litigate because it's a lot of work. And the sad truth is that across all walks of life, across all industries, people a lot of the time take the least restrictive means. They don't really want to be fighting too much and fighting too hard. And
you got to front the cost of this shit show for 3 years or 4 years or whatever it is, right? So
not to mention the stress, right? I mean, I feel like we don't talk about that enough.
The mental health side.
Yeah, there's a huge. I mean, getting sued is. I've been around lots of people who have been sued just civilly, their businesses, and it's stressful and for years. It's not like 3 months. Yeah. It's years and years of stress of what the fuck's going to happen and where am I going to be a year from now, and it's
but to the insurance company, it's like a line item on their fucking books. I don't give a shit.
I'm talking about the actual individuals involved on both sides, frankly.
Yeah, no, I mean, listen, the defense. I mean, look, there's a reason why, and it's on the mental health side. I mean, why suicide is actually as prevalent as it is, in the legal practice, and why that does take place. And it's because it's very demanding and it's very difficult. You're away from your family. You might be questioning what you've been doing for the last 10, 15 years and where the time has gone. And it is something that the defense attorneys who are representing the insurance companies will suffer and deal with just as much as, say, a personal injury attorney or a criminal defense attorney or a trust attorney or immigration.
Secondary post-traumatic stress syndrome, like secondary PTSS.
Right. And but with all that stuff being said, insurance companies know and understand that personal injury attorneys or attorneys in general, litigating attorneys, don't always want to push and create that pressure because it's a lot of work. Yeah. And so they know, and there was actually a study done back in the 70s or 80s where insurance companies basically realized that they can withhold settlement on all of these cases and they won't get sued all the time, and they know that a certain percentage of them are going to settle another portion of the time, and because there's a small percentage of them that will make it to litigation, that will actually make it to the door and go to trial, and so that they will end up making more money by withholding actual settlements, by keeping it in a T-bill, by keeping it in the stock market, by putting it in some other avenue of investment to basically be accumulating this wealth while they are then going to pay a settlement, let's say a year and a half down the road, with the interest that they just got done making on whatever the principal was.
Yeah.
So that's the thinking, and that's the thing that people don't really think about all the time. I mean, and this is, it's really like the trend that Florida is kind of like embarking on, and the direction that we're going is, yes, it is true that there are fraudulent claims. It is true that insurance companies can get taken advantage of, and they do in some instances, and that needs to be protected. But it's also true that there's currently mechanisms in place, that actually prevent and deter that type of behavior without there being a massive tort reform project, without the governor having to go and actually give a handout to insurance companies in these spaces. And if you want to look at no other example, and it doesn't even affect me in my personal injury space, it's in the property damage space.
Oh my God.
And there was fraud taking place, in that space, but there are also a lot of legitimate claims in that space. And one way you can deter against fraud is you can file 57105s. You can file proposals for settlement, which are things that would actually put the injured party, say the insured in that situation, the homeowner, potentially on the hook for the hundreds of thousands of dollars that would be at play in that lawsuit if the defense attorney won and the insurance company prevailed in that lawsuit. But what you also need if you're going to file a 57105 is you need judges to actually be willing participants in the process and not be afraid to sanction attorneys or sanction, say, the moving party if it is warranted. And sadly, in a lot of instances, at least at the state level, state judges are elected, and so they're more concerned, sadly, about punishing the moving party or the bad behavior that's taking place, which then may create a reason or a need for laws to be changed in a way that's going to hurt the consumer. And so if you have a situation, let's say I'm a homeowner, I don't know if you guys, own any property, but one thing is clear, is that for decades in the state of Florida, if an insurance company did not pay out the money that was reasonably owed to the homeowner, and that insured had to bring a lawsuit against their insurance company for $5,000, for $50,000, for $500,000, whatever the damages were, and they prevailed, the insurance company would be responsible for paying the attorney's fees. That existed for a reason, an important reason. And that was because if you had a $5,000 damage, to your windows or to your roof, and attorneys sadly get paid, well, not sadly, but it's just like that's the way it is, and we as attorneys should not be backing down for the fact that we command and earn a lot of money either, because that's the reason why we went to school and gave up a lot just to kind of go through that process, right? But at the same time, it's not cheap, but it's more expensive to bring a lawsuit that might be only worth $10,000 to the insurance company. And so what the law is trying to do is trying to create an incentive for the consumers to be protected and also to incentivize the insurance companies to pay for a $10,000 recovery or $5,000 recovery. And the only way they can do that is by making sure that that homeowner is covered and going to get back everything that they owe for that $10,000 damage, and the insurance company is going to have to pay the $50,000 attorney bill at the end of that litigation. Now, what just happened as a result of Governor DeSantis changing the law is that no homeowner can ever be made whole.
Yep.
You can be paying tens of thousands of dollars for 10 years to your insurance company. They're making money hand over fist. You then want to make a claim for $12,000 for windows that happened at your property because of the storm that came through. They can tell you, fuck you very much. You're then going to go to an attorney and say, hey, here's a $10,000 claim that we have here. And the attorney's going to look at you and be like, hey, I'd love to help you. But, I'm going to be spending well more than $10,000, not just in my resources, but also in the cost to push this case forward. So I'm not going to be able to help you.
Yeah. And 10,000 is a small claim. To your point, the small claims are going to get fucked. That's really what it comes down to. But even slightly bigger than that, we had a property loss at our house. We had a flood.
Yeah.
Give or take about a $40,000 to $45,000 loss overall. It was a pain in the ass to get the insurance company to offer anything even close to that.
100%.
And they were evaluating. I think I said this on one of our other episodes. They were evaluating the walls where drywall cost 4 cents, and I'm like, really? Where is this magical drywall?
No, 100%.
This magical Home Depot where everything is pennies on the dollar.
But think about this though too. That's just say the people that are on the lower end of the damages side, or $10,000 claim, a $5,000 claim. You're gonna have a $500,000 claim, right? Yeah. You might have a multi-million-dollar home that you might say live in, and you have a $250,000 roof that needs to be replaced. Okay. Great. I guess the attorney that's going to move forward on that claim, he's going to get 30 or 40% of that potential recovery, and that's going to be able to kind of pay for his time that it took to litigate that case for 2 years. But what is the homeowner going to do after he gets that money? They're going to build a fucking 70% roof. Hey, I put a roof on this side of my house, but this fucking side is completely open. So when Hurricane Lucy comes by, exactly.
From the magic Home Depot.
So it can't be beyond unfair, what it is that happened in terms of the handout that was just basically given to the insurance companies.
But it wasn't just property now. I kind of want to come back to personal injury. Yeah. Some really interesting cases. So I knew someone who used to handle a lot of personal injury cases related to negligence on commercial property. So, for example, if someone had a 7-Eleven and late at night someone got
security
shot in the parking lot. That's the negligent security cases, right?
Yeah.
There's big changes now with how those are handled too, right?
Yeah.
I'm not talking about money, but I'm talking about who's at fault and how they determine that. Can you explain that a little bit?
Yeah. So in the premises liability context, it's really very similar to even a slip and fall case. There was a danger that existed that you knew or should have known was there, and you had a duty to protect your consumer, the patrons that are coming onto your property.
Right. So in my example, the 7-Eleven has, let's say, a dark parking lot.
Correct.
There's been multiple robberies there.
Shootings.
You don't have any cameras for security, no guard, et cetera, and lo and behold, someone gets shot in your parking lot.
Exactly.
ElIna really loves to get Slurpees at midnight.
Yes.
So 7-Eleven.
We were definitely at 7-Eleven last night getting Slurpees for the record. But that was not my idea.
What flavor though? Was it Coke? Yes.
Of course, the Coke.
Yes, I used to go with my aunt all the time when I was a kid.
I mean,
Yeah.
It's the
old habits die hard.
I think she's asking for it.
Hard,
I think she's definitely trolling 7-Eleven parking lot.
So the question is, if I get shot at the 7-Eleven parking lot,
which I hope does not happen. I mean, I just want to say for the record, yes. Yeah, here, right here. But yes, obviously that is the case that we will be able to do and help you with. But yeah, in a situation like that, they're profiting off of the public, so the business, and the reason why the law exists the way it does is that it's trying to protect those people that are actually giving their hard-earned money to those businesses and incentivize the businesses to protect the people that are keeping them afloat, right? And so if they know that at their particular location in their particular part of town, there's a high rate of violence, robberies, burglaries, shootings, murders, whatever the situation is. And there were instances that happened within a mile of that particular location, or even at that location before it even happened. And they didn't have security guard. They didn't have any signs hey, don't. I mean, that's the reason why, by the way.
Don't come here at midnight to get
you'll see signs like.
I mean, I totally get it, right? As a business owner, if in my parking lot there's been people mugged at gunpoint multiple times, at some point you're like,
and interesting because I think of the parking lot, but you're saying you could even use evidence of stuff happening half a mile away.
Yeah, for sure. Because I mean, it's
next door.
Yeah, you have to make sure that that your community is aware that this is a very dangerous part of town. If it's something that may impact them.
So hold on. Yeah. I mean, so if I'm a 7-Eleven owner, I'm just not opening a 7-Eleven in the ghetto. This is just not happening.
No, you are. But
he's like you are, but
any protection.
But because you want to make sure you're protecting the people that live in that community too. Because if you're going to go ahead and basically, because what you will also see, if you've ever seen The Wire, have you seen The Wire?
No.
Okay, so in The Wire, you would
Law
see
and Order. No,
not
no.
The
Wire. None of that wholesome shit.
You'll see. Let's say you watch an episode of The Wire, and you'll see that gas station, 7-Eleven or wherever, and you see hand-to-hands and prostitutes and things like that in just broad daylight, right? In a lot of parts of Miami, New York, LA, that stuff is going down.
Sure.
I mean, when I was a young public defender, I actually had a case after at a very place that I was defending somebody that had been arrested at this location. And you go in there, broad daylight, you're just seeing hands-to-hands, you'll see literally drug wrappers and stuff like that on the ground. And what's happening? That business is still operating. Right? They're not putting security in place. They know that the drug dealers are using their place to basically sell to the public. Now, what's going to happen when a drug deal goes wrong and then one of your fucking patrons gets shot and killed? And
or your employees.
Yeah, correct. Exactly. All of those things.
Don't open a 7-Eleven in the ghetto.
Or if you are going to own a 7-Eleven in a bad part of town, just put in the necessary security precautions to make sure your people are protected.
And what does that look like?
A security guard, lights,
cameras.
Bulletproof.
I'm this is a whole other part of your law firm, consulting on how to not get
those
sued.
Slurpees at midnight, there's a little window sometimes they slide over after a certain hour, and you have to do, at gas stations, you have to do all transactions through the little plastic.
Or have you
seen... How does that help people getting shot up in the parking lot?
No, well, have you seen the signs where it says, do not leave valuables in plain sight or in the car? That's all about creating notice, for the people that are coming in.
Yeah, don't be stupid.
Yeah. But I guess to just bring it full circle, so that's kind of like the no, it's okay. But that's a part of the example of what a negligent security case might look like. Is the business owner is not putting precautions in place to protect his patrons. Something happens, and then you, as the patron that's injured, can sue that property owner or the business that was operating there. Now, historically, the focus, and this is correct and where it should have been. When you're bringing the lawsuit and the action against, say, any business, where this is happening, a Tom Thumb, a 7-Eleven, whatever, and these are just examples, you would sue them, and they would not be able to then show that the defendant, say the person that murdered the person on that property, was responsible, right? Because what that's doing is it's deflecting the focus of the civil process from one that's civil to one that's criminal, right? This was never about was this person responsible for shooting this other person? No, it's not about that. That person 100% was responsible for shooting and killing somebody or injuring them on your property. The difference is did that business owner know, or should they have known, that was likely to happen? And did they take precautions that could have prevented it? Right? And so before the law change in March of 2023, you would not be able to put the name of that defendant, that criminally accused, who's now looking at a life sentence, on the jury verdict form. and say, to the jury, who are you blaming? And how much of that blame are you putting on the person that did the shooting, and how much are you putting it on the 7-Eleven, the Tom Thumb, or the business? It seems
obvious that most juries will say, "Oh, the guy who did the shooting."
Right, because not everybody, is a lawyer or has that legal education.
Are you just allowed to name them? Or are you allowed to talk about them? Are they allowed to talk about them in the trial?
The defense, in essence, really is what's going to end up happening now is that the defense is going to be able to list the name of the person that was accused or arrested, and they are going to basically kind of put on a separate case in essence, right?
Right.
I'm going to be trying to say, hey, this business is responsible for creating this dangerous condition and not giving any necessary warning or notice to the patrons as they're coming onto the property, and that's why John Smith, coffee company is responsible for this shooting that occurred on their property. The attorneys on the defense are just like, John Smith, isn't responsible.
Jose
for this.
is.
Yes. Why is he got to be Jose? Why is he got to be Jose?
It could be Chris. It could be Jose. You want me to say Carlos?
Like, there's
Monica. But are you allowed to mention them over and over again in the trial?
Well, yeah. So what you're going to do is,
as attorney to the defense,
you're going to be able to talk about and show. This is obviously all is being rolled out obviously this year. We're in 2023 still, and so there's going to be a lot of trial and error in terms of what is and what is not permitted. But the one thing, the primary thing is like by just having the name of the person that the defendant is now saying is responsible for this is going to provide a good amount of confusion to the jury.
Sure.
And frankly, is devastating to the practice of negligent security, law. And it's sad and it's unfortunate because there's a reason why the rules of evidence and the rules of civil procedure have existed for hundreds of years, and the rules of evidence, it's been tried and true, and they've been developed and honed for a reason. And they're there to protect the public that don't have that legal training to understand what should and what shouldn't come into evidence. That's not going to unfairly prejudice the jury. That's going to then affect their substantive rights,
But that's just the verdict form. So my question is, can I call him as a witness? Like, can I put Jose or Monica or Carlos and be like, so Monica, why did you
now
make
that you're sitting in jail for 30 years?
Well, good luck.
Tell us.
Yeah, there's good luck getting somebody that's being accused criminally and facing potentially a life sentence to come in and be like, hey guys, it was me. That's not going to happen. What would potentially happen?
Well, from the defense side, so why'd you pick this location? Yeah. Oh, because it's dark, because there's no security.
No. The defense of putting them on, they're going to say the opposite.
Well, they're not going to say much of anything.
Right.
What they're going to say
is, this is totally random.
They're going to plead the fifth.
Yeah, I'm going to invoke my rights. They're not going to end up saying anything. And by the way, how great does it look when you invoke the rights in front of a jury anyways?
Then you look really guilty.
You know what I mean?
Yeah.
And so that it's a very sad situation because we had a case where our client was actually shot 6 times in Liberty City, going to a neighborhood store at night, could walk to it. Great dude, great family. He was actually a train conductor here in South Florida and for the Tri-Rail system. And he was in a coma for 10 days. And he had hundreds of thousands of dollars in medical bills. And in that particular situation, there was a rivalry between some drug dealers and stuff like that, and he got caught in the crossfire. And he was one of 3 other people that got shot. And in that situation, frankly, there were a lot of other factors at play in that particular case on the coverage side. But the one thing that is clear is that it would have been a very different situation if we would have had to have gone and proven the case, against the liquor store, or not the liquor store, but the convenience store, and saying that they were responsible because there had been a murder that took place there literally a month and a half before. Or all the robberies and drug deals that happened in broad daylight, because that actually was the store that I had been to as a young public defender and seen what took place there. I actually had a friend of mine that was a public defender that actually was representing somebody that was being accused of homicide at that particular location in the months prior to my situation. So it was no surprise that it was dangerous. But if the defense in that situation was then allowed to put in the name of the drug dealer, or whoever was accused, my client would not have been able to get a 7-figure, resolution in that case.
Sure.
Or he may have, but he also very likely might not have, because a jury would have said, why are we going to blame the small fucking business for this when that piece of shit is out here murdering people? they shouldn't be, at fault. And what that's doing is it's really inflaming their passions, and by focusing on the very obvious fact of what this person did was wrong, but really completely ignoring the preventable measures that the business could have taken.
Makes sense.
To prevent this from taking place. So.
Yeah. And that's just one of the changes that have happened with the tort reform in Florida, right?
Yeah.
Some other things like lowering the statute of limitations, which just makes it harder for people to get their shit together. You got to get your shit together faster, get everything filed. Wasn't there like a mass filing situation that happened? Yeah. I remember this in the news down here where it was like, I don't remember if it was hundreds of thousands or just thousands of cases that were mass filed to get in before the statute changed.
We're not a big, massive volume practice. We don't have cases like a Rubenstein or a Morgan & Morgan and stuff. We're more boutique. I
think it was Morgan & Morgan that came out with their statistics.
Oh, yeah, for
publicly.
sure.
That was nuts how many cases they filed.
100%. But they were doing it, because there was a real need for it. They weren't doing it for any other reason other than, the environment that existed that was created by not just the insurance companies but by the governor in the state of Florida, Governor DeSantis. He pushed this through. Mm-hmm. And so not only are there going to be challenges saying that it's not retroactive, and there's a decent case with it, but the reality is that there's going to be very attorneys did not want to take the chances, rightfully and justifiably so, that they would be able to be successful in appeal when the Florida Supreme Court has been, potentially, benched by Governor DeSantis, and want to take the chances that with the very judges that have been put on the bench by him are then going to somehow find against Governor DeSantis when this was the law that he just basically put into effect. So that's one thing that people did not want to take, a chance on. And there is, some good legal arguments to make. And frankly, if the jurists there are analyzing the law, the plaintiffs on that side should come out victorious, and it should not be retroactive. But at the end of the day, you would have to, number one, go through years of appellate work just to kind of make that happen.
No, this is retroactive to the incident date?
Correct, yeah. Because basically what was happening is in the law, it would basically say that, anything that was filed after this date will be under the new law. Anything that was filed before this date will be under the old law. And so it basically created a bookend for every personal injury practice in the state of Florida to say, hey, listen, if we're representing our clients in their best interest and to make sure that they're maximizing their recovery for their injuries and how they've been harmed, we need to make sure that all of these lawsuits are filed before. Okay? Right. And so what ended up happening is, there was a race to the courthouse. Tens of thousands of lawsuits have been filed literally in a week-long period. At our law firm alone, we filed, I think, 65 lawsuits in a 2-day period, That's crazy. And the sad truth is that, and this is going to hurt the hurt consumers again, right? Because we already established that insurance companies know that not all personal injury attorneys try cases. They don't all go to court. They don't all litigate. And as a result, they now know that because not all attorneys are doing this, and really to maximize those recoveries, unless you're one of those attorneys that do that, you're not going to be bringing those lawsuits anymore, right? Unless you're giving those cases to attorneys like us that actually try cases and litigate them. But that was pretty terrible. And the other thing that it's doing is it's allowing those insurance companies and the defense attorneys to go to the insurance companies and say, not the insurance companies, but go to the legislature and say, hey, do you see this ridiculousness? 30,000 lawsuits in a week? This is going to put the defense bar out of work, or they're going to there's going to be a mental health problem. You got to do something to control this. And this was all onset by the insurance company lobbying the governor to say that this is all taking place, and then showing the environment so that they can then go and start what they're trying to do, which is really try to perform more tort reform in the state of Florida. And this is just the beginning of what they're trying to do, In
response to that, I want to talk specifically about Florida statistics for a moment. So in prepping for this podcast today, you sent me some really interesting articles, and I actually wrote down some of these numbers because I had to ask you about it. And the article you sent me said that Florida leads the way with, I think I wrote that down. Well, no, with 1,237% more filings than the national average. Right. Is that accurate?
Cool, that was
crazy to
That's
me.
fantastic.
And it said that per 100,000 people, Florida had 127.41 cases in court. 127.41 compared to the national rate of 9.53.
Right.
That is outrageous. So I gotta ask you why.
Well, is that per population,
Yeah,
per
that's
area?
per capita.
Like, how are these statistics being?
If I'm
there are lies and there are
correctly,
statistics, right? So,
yeah. Well, if we're talking about the same article, I believe that article was talking about 2023 and talking about the numbers of 2023.
Yeah.
And that was done obviously directly in response to the tort reform, right?
Gotcha.
So that's not like the historical average.
Oh,
that's not how.
I definitely read this like we sue people more in Florida.
Yeah.
Why?
Yeah.
I guess that makes sense.
Correct. Yeah. I mean, listen. Florida does seem and does happen to be a pretty litigious place. When compared to a lot of places around the country. I wouldn't necessarily go to say that it's like just exponentially higher here than New York or any other big city. But I would say that if you were going to affect the rights of consumers and injured parties in the state of Florida the way you just did in 2023, then yeah, you're going to create a massive influx of litigation into the court system.
And what do you think, what kind of repercussions do you think this is going to have?
So, I think that the most obvious one, which I think is just a part of the plan, of this big lobbying push, is to basically, show the rest of the population in the state of Florida that are not perhaps injured, that have not necessarily brought lawsuits, like, oh, look at us, nobody wants to do business here, the insurance companies are going to get hurt, all your premiums are going up because of all these frivolous, lawsuits and all of these greedy trial lawyers, and they're going to completely take the attention away from the fact that, Governor DeSantis is the one that's responsible for creating this massive push. And, there's going to be millions and millions and millions of dollars in lobbying efforts that's going to go towards trying to convince voters otherwise.
Do you think more of these cases will settle as a result of just having so many of them in the pipeline?
I think right now there's a lot to be determined. For a firm like us...
I know, I'm asking you to speculate.
No. I think for a firm like us, there's a lot of opportunity in moments of crisis, and that's the sad truth, because, we try cases, we've been doing that. And I think as a part of us, like even understanding our numbers and knowing, the value proposition that we provide as a law firm, one of the things that actually I had, as I get ready to enter 2024, we're just going over the numbers, and we're looking at some of the law firms that we do business with, and how long they would have the case on average and how long we would have the case on average, what their highest offer was for a firm that does not litigate compared to a firm like us that does litigate, and what we would see on, say, a sample size of 50 cases. And what we found was of about approximately 50 cases, the average settlement value per case for that firm was around $9,000, right? Our firm, when we had that same case, and we put it in, that's based on their highest prior offer before we got the case.
Okay.
When we put that case into litigation and ultimately settled it, we settled it for an average of $97,000.
Wow.
Right? So that was the increase. The time that the prior firm would have the case was 18 months. The time that we would have the case would be about 6.5 to 7 months. Okay. And I think the total settlement, if you were to take all of those cases, you add them up, and the total offer of settlements between the zeros that were offered and the actual numbers, it came out to be like $278,000. The settlements that we got on all of those cases was $2.8 million. And so you're able to see just the amount of value that you end up instilling in the cases for the cases to actually litigate, try cases, right, and provide that pressure.
Yeah, I think generally the public is more afraid of litigation as an overall.
Yeah, right? Yeah, for the public and the businesses and the insurance companies,
right,
for sure.
People
yeah,
involved.
Exactly.
Not the lawyers.
Yeah. Well, to be honest with you, lawyers too. Because
I live in litigation world like you, so it doesn't.
But lawyers too. Because to be honest with you, there's a certain type of panic that you see coming from the other side when people call themselves trial lawyers, but they don't really like the pressure, and people do kind of crazy things. So what I see happening though is firms that try cases and litigate are going to benefit. The ones that don't are going to either leave the practice and go somewhere else, which is probably going to be a net benefit, or they're going to work with other trial lawyers and trial firms that make this a big part of their practice.
Yeah,
so that they can, correct, exactly right. And so that's something I think is going to happen. You have a lot of attorneys that I know that are leaving the state of Florida and going to other states too.
Yeah.
And
here, Kentucky's a good place to go.
I don't know much about Kentucky, but
that out there.
Kentucky's a beautiful place. I know that.
What?
Have you been?
She has, actually.
So
oh my God, because we accidentally crossed from Cincinnati, Ohio, and found ourselves.
My mistake.
Found ourselves
have you been
in a dark alley in Kentucky.
You have not been to Lexington. You have not been to Lexington.
No.
You have not been to Louisville.
I try to stay away from crazy white people, Dylan. I don't know.
You just want to stay around the crazy Cuban people.
Yes. I feel at home with the crazy Cuban people. It is, but we have a handle on this kind of crazy.
No, this is a sunny place for shady
people. I know. I mean, for sure. But
no, you definitely should go to Lexington and Louisville. They're both beautiful towns, and you'll have a lot of fun.
He's going to open a practice there. He has to start kissing us now. On the billboard. Dylan on the next billboard in Kentucky.
But anyways, thank you so much, Dylan, for joining us today. And before we let you go, is any final thoughts for anyone listening or watching? Anything public needs to know?
Fuck the insurance company.
That's Leslie's final thoughts for you all.
That's not exactly how I would phrase it.
He's like, I didn't say that.
No.
We're a little more.
I was going to say, fuck Governor DeSantis. That's what I heard here too.
I'd say thank you very much for having me on. I was really enjoyed myself. It was really nice coming in and sharing this time with you guys.
I see Dylan lobbying. That's what I see Dylan doing in the future.
I mean, listen, lobbying for consumer rights, and for people that are injured, 100%.
Exactly.
So our
You're
firm
a passionate guy, Dylan.
I can be from time to time.
Don't make fun of him. It's a good thing.
No, it's okay.
I'm saying that with for real.
I appreciate that. We are very passionate. Our firm is here in Coral Gables in South Florida. We service all of Florida. The name of our firm is Cornish Hernandez Gonzalez. It's me, Igor Hernandez, my law partner John Sullivan, Cam Cornish, and then we have two law associates, Dylan Boygris, who just came on. We're super excited to have him part of the team, and Ira Combs. And then we have a staff of about 15, others, paralegals and support staff that are helping us. For us, every case that we have is very much a privilege for us to be able to kind of represent, our community and just give back, because I think that although there aren't all clients that are very grateful for the work that you do, when you do have the people that are grateful, you're paid in spades, and it's just it's a blessing to be able to kind of be out there and helping people.
So it must be really rewarding work overall. I mean, it sounds like it is, right? You actually make a difference every day, which is really cool.
Yeah, I mean, we try to make a difference, every day, and it is really rewarding. I mean, I think just being an attorney in general, I think, and it's really easy to kind of lose sight of that, whatever practice you're in, because it's pretty overwhelming with pressure. Sometimes you don't have the nicest clients; they're always calling. You've got family, real life.
The day-to-day.
But it's a privilege to be able to kind of represent people and just fight for the underdog against insurance companies and big business.
I love that, because I have that idealism in what I do. Not so much over there.
Well, I thought you said that you wanted to be a public defender back in the day.
If money didn't
yes.
What?
No, I thought because she said that you didn't care about the underdog. I said, but public defenders, that's all they do is fight for the underdog.
Yeah,
I mean, if you want
that is a whole different conversation, my friend.
That Leslie's ideal job would be a public
different
defender.
Conversation. And actually, it is not public defender. I wanted to do Fourth and Fifth Amendment.
Appeals.
It's not necessarily
now.
That's right. I'm sorry. It's appeals.
And this comes from a whole nother dinner party question that she asks lawyers.
This is a conversation for another day.
Hundreds of lawyers at a time. What is their dream job if they didn't have to do what they were doing?
I always ask. Now you've talked about it.
Now we have to go here. We have to go here.
So I have a dinner party conversation I need to ask people. Maybe I've asked you. I don't remember.
Maybe we're asking him right now.
You should ask me right
that's
now.
it.
And the question was, in a world where money didn't matter, so all your needs were taken care of.
This is a commie state.
It is not a commie state. You always make my question
the same amount of money no matter what you do.
It is not. It's your needs are taken care of. Right. So money is not an objective. It's not a consideration. Just take money out of the equation completely. Just forget it. It doesn't exist in this universe, right? So in a world where this doesn't exist, but you have to work. You have to have a job, and it doesn't have to be a 9 to 5, but you have to have a job. So sitting at home and watching movies is not an option.
Right.
You must work.
Yeah, do something.
And the same amount, more or less. It's not like one person works 3 hours a week and the other person works 40. Everybody works the same amount of time.
Everybody works, right?
Again, commie state. Commie state.
We're back to calling it a commie state.
Yes.
But whatever. In this universe that does not exist, if you had to pick a profession, what would that profession be?
It's not as sexy and
that's okay.
and exciting, but I'd probably do exactly what I'm doing.
Would you really?
Yeah, I really would, because I fell into it, but I'm very happy that I did. At the time in which I went to law school, I was an athlete my entire life. I played sports from the time I was 4 until I was about 25, 26, and I did not know what I wanted to do. And my family weren't lawyers, doctors, and stuff like that. And so it was the height of the recession. I know I needed to go to grad school, whether it was business, medicine, whatever. Going to law school was like the most accessible thing for me at the time. And it also covered all the bases in terms of all these different industries that I could potentially work in, whether it was business, trial work as a public defender, personal injury, whatever. And so I went to law school as a safety, to kind of like discover a little bit more about myself. And then when I was there, I actually met my law partner, Igor Hernandez, and, had developed a bit of a bro crush.
A bromance.
Yeah.
It was a bromance.
And we'd be on trial team, in our second year of law school, arguing about fucking rules of evidence at 1:30 in the morning on a Saturday, because all of our weekends were consumed with prepping these fake cases to these competitions. And in conjunction with just like the legal satisfaction and just like understanding the law, the other side that I was a little bit of an artist, when I was in high school, and I enjoyed just creating things. And so the storytelling aspect of being a trial lawyer was like quenched. It really quenched that creative side of me. And so discovering the whole world of persuasion, how to persuade, how to tell stories, themes and theories and different things like that.
Triads.
Yeah, correct. All of that type of stuff. And
I love that stuff.
And so
for
me,
a whole podcast episode just on storytelling.
Oh yeah, it's incredible. And so like, and everything you do in life is a form of persuasion. Whether it's the news, lobbying, trying cases and storytelling. We're all being persuaded in different ways. And so for me, it was incredibly impactful for me to be able to do that and then also help people at the same time in the personal injury space or as a young public defender. The dream for us is to continue building and developing our practice, and be able to be a little bit more selective to work on less cases throughout the year and really choose those cases where we want to dedicate our time and sit down and mock try them and put together these incredible stories and bring it to in front of a jury.
I love that. So you see, he'd be a lawyer.
Yeah.
So I will tell you that the results of my straw poll are.
And she's done this to like hundreds of people at this point.
Almost no lawyers say they want to be lawyers, which is why I started this episode by saying he's a happy lawyer because he actually likes what he does.
Yeah.
But
we've had a lot of people say they want to go back and play a sport that they love to play.
Sure.
Yeah. A lot of people we have a friend, right?
Yeah.
They want to sell their jam at the fair,
at the farmer's market,
whatever.
It's interesting. The results are interesting, but it gets to the root of who you are and what makes you tick.
No, right? For sure. And I think that one thing I would say, and I don't have kids yet. I'm not married or anything like that. But if I'm blessed enough to have kids, I look forward to being able to share with them some of the experiences I had and some of the good and the the bad and some of the teaching moments. And one of the things for me, it would revolve around would be just like athletics. And because it was obviously a big part of my life for so long and shaped me into everything I really am today. But one of the reasons why I did not go back and I didn't really long to kind of, want to continue playing ball was because there was so much out there that I didn't feel that I was able to partake in. Whether it was traveling, I was kind of a geek. I enjoyed geopolitics, international relations. I had an internship at a think tank in DC the year I got drafted, and I never did that, right? And I couldn't go and study abroad when I was in college. And so there's a lot of sacrifice that you make there. But the reason I'm bringing that up is because I wanted to leave the game to go and do these other things, so I felt like I was living a meaningful life. Now, if I were to look back, because I've been fortunate enough to kind of give back, whether at the public defender's office or at a personal injury practice and helping people, I feel that my body wouldn't be able to necessarily do it, and I'm too old for it, but mentally, I would be in a better place to be a more dedicated professional athlete. Because when you're a professional athlete, you eat and sleep and drink it. You're training during the season and the off season. Everything is in anticipation of what's coming, and you always have to make sure at the top of your game. And with anything that you're doing, whether it's sports or legal work, if you want to be at the top of your game, you have to be fully committed and all in. Yeah. And so, at the time, I did not want to be, completely committed. I have no regrets on how my career ended, and I was very happy with the way I finished. And frankly, I was continuing to play well, and I could have played. But I knew inside that's not where I was, Now, because I have these other experiences, I would be better because I'd be more focused and more dedicated.
Well, it's also been years, right? You grow up.
Yeah,
after a certain
no,
amount of time.
for
change,
sure,
you
for
evolve,
sure,
I think is the word.
For sure. But the reason I'm bringing that up, though, is I think it just kind of speaks to the importance of people having all sorts of experiences. And sometimes, the same way I kind of got tired of playing ball because there were other things out there I needed. The attorneys that want to leave the practice of law to go start a podcast, or maybe, become an engineer or a pilot. They may not have had these other diverse experiences leading up to the moments where they chose to what they're going to do for the rest of their life,
I hear that.
So
I love that.
It's balance.
I think that's a great closing thought. So with that, we're going to let you go, Dylan. Get back to work. Thank you so much for joining us. This has been ElIna Santana and
Leslie Marenko
with Law Shit You Should Know, and see you again next week.
Yeah.